This is not a drill, and I genuinely mean that. What I'm about to share with you in this video could fundamentally change how you operate as a landlord in the United Kingdom. The Renters' Rights Act has just dropped a bombshell that very few people in the property industry saw coming, and there are new clauses that are now being marked as mandatory. Not optional, not recommended, but absolutely mandatory for every single landlord in England. If you are not paying close attention to what I am about to explain, you could find yourself on the wrong side of the law within a matter of months, facing fines that could genuinely devastate your property business. I have spent the last 2 weeks going through every single amendment, every clause, every piece of guidance that has come out of Parliament regarding this legislation. I have had conversations with solicitors who specialise in property law. I have spoken with letting agents who are already scrambling to update their processes. I have spoken with landlords who are genuinely panicking about what this means for their portfolios. And I'm going to break it all down for you today in plain English, without the legal jargon, without the confusing terminology, because the mainstream media is not covering this properly, and most landlords across the country have absolutely no idea what is about to hit them. Before I get into the details of these mandatory clauses, I need to ask you something important. If you own rental property in the UK, if you are thinking about becoming a landlord, or if you are a tenant who wants to understand your new rights and what protections you will have, you need to be subscribed to this channel right now. I am not asking for fun or because I enjoy seeing numbers go up. I am asking because the information I share on this channel could save you thousands of pounds and keep you out of serious legal trouble. We are a growing channel in the UK property space, and we are growing fast because we tell the truth about what is happening in the rental market. So please take 2 seconds right now. Hit that subscribe button that you can see on your screen. Tap the bell icon so you get notified every single time I post a new video. It costs you absolutely nothing, but it means everything to this channel and helps us continue producing this vital content. Do it now, and then let us get straight into this because there is a lot to cover. So what exactly has happened with the Renters' Rights Act, and why is everyone in the property industry talking about it? Let me take you back a few steps so you understand the full picture and how we got here. This legislation has been in the works for several years now. It originally started life as the Renters' Reform Bill under the previous Conservative government, and many landlords across the country genuinely thought it would quietly fade away or be watered down into something far less impactful. That did not happen, not even close. When the Labour government came into power, they picked up that bill. They supercharged it with additional requirements, renamed it the Renters' Rights Act, and they have been pushing it through Parliament at a speed that has caught virtually everyone in the industry completely off guard. The core elements of this legislation you probably already know about if you have been following property news at all. Section 21. No-fault evictions are being abolished entirely. That is the headline that grabbed all the media attention and sparked countless debates. But what most people completely missed, what most news outlets and property publications entirely failed to report on, are the new mandatory clauses that have been added in the final stages of this bill. These are requirements that every single landlord in England will have to comply with. No exceptions whatsoever, no grace period in some cases, and the penalties for non-compliance are genuinely severe. Let me start with the first bombshell, and this one is absolutely crucial for every landlord to understand. There is now a mandatory requirement for all landlords to register on the new property portal within a specified timeframe once it goes live. This is not going to work like the existing tenancy deposit schemes where you have 30 days to protect a deposit. The government is establishing a comprehensive national database of every landlord and every rental property in England. You will be required to register yourself as a landlord on this portal. You will need to register every single property you let out, regardless of how many you own, and you will need to keep that information continuously updated whenever anything changes. If you fail to register on this portal, you will not be able to serve valid eviction notices, full stop. Let me say that again because it is absolutely crucial, and I need you to understand the implications. If you are not properly registered on the property portal, any eviction notice you serve will be completely invalid. You could go through the entire court process, spend thousands of pounds on legal fees, wait months and months for a hearing, and have the whole case thrown out because you were not properly registered. All that time money, and stress completely wasted. But it actually gets worse than that. The property portal is not just a simple registration system that sits there collecting information. It is being designed as a comprehensive enforcement tool. Local councils across the country will have direct access to it. They will be able to see immediately which properties are registered and which ones are not. They will be able to cross-reference this data with council tax records, electoral rolls, energy performance certificate databases, and other government systems to identify landlords who have not complied with the registration requirements. And the fines for failing to register are going to be absolutely substantial. We are talking about civil penalties of up to £30,000 for serious or repeat offences. This is not a minor slap on the wrist that you can simply ignore or budget for as a cost of doing business. This is financial devastation for smaller landlords and even a serious blow for larger portfolio holders. Now here is where I need to pause for a moment and say something important to everyone watching. If you are finding this information valuable, if this is genuinely news to you and you are learning things you did not know before, then please do me a favour right now and share this video with another landlord you know. Send the link to your WhatsApp groups, post it on your Facebook page, email it to your property investing friends and colleagues. The more people who understand what's coming, the better prepared our entire community will be to navigate these changes successfully. And while you are at it, if you have not subscribed to this channel yet, I have to ask, what are you waiting for? This is exactly the kind of content that could save your property business from making expensive mistakes. Hit subscribe right now and let us continue with the rest of these mandatory clauses. The second mandatory clause that has been added to this legislation relates to the Decent Homes Standard. Now you might be sitting there thinking that you already know all about property standards and compliance. You might think your properties are already fully compliant because you have up-to-date gas safety certificates and you have had the electrical checks done. But I need you to understand that the Decent Homes Standard that is being made mandatory for the private rental sector is far more comprehensive and far-reaching than anything we have ever seen before in this industry. This standard was originally designed for social housing, and it covers things like the overall state of repair of the property, the age and condition of kitchens and bathrooms, the thermal comfort of the property and how well it retains heat, and whether the home meets the statutory minimum standard for housing. Under these new rules, if your property fails to meet the Decent Homes Standard, you could be prohibited from letting it out entirely until you bring it up to compliance. Councils will have the power to issue improvement notices requiring you to bring the property up to standard within a specified time frame. If you fail to comply with these notices, you face substantial fines, rent repayment orders where tenants can claim back rent they have paid, and potentially banning orders that prevent you from being a landlord altogether. And here is the part that is really catching landlords off guard. The definition of what constitutes a decent home is going to be applied retrospectively to existing tenancies. You cannot claim that your property was compliant when you first let it out 5 or 10 years ago. If it does not meet the standard now, today, you are in breach of the requirements and subject to enforcement action. The third mandatory clause concerns what is known as Awaab's law. You may remember Awaab, the 2-year-old boy who tragically died from respiratory problems caused by extensive mould in his family's social housing flat. That heartbreaking case shocked the entire nation and led to new legislation requiring social landlords to address hazards like damp and mould within strict timeframes. Well, under the Renters' Rights Act, Awaab's law is being extended to cover the entire private rental sector. This means that if a tenant reports damp, mould, or other serious hazards in your property, you will have a legally mandated timeframe to investigate and begin remedial work. We are talking about 14 days to investigate the problem and a further 7 days to begin repairs in emergency cases. For less urgent issues, the timeframes are slightly longer, but they are still strictly enforced with no flexibility. If you fail to meet these timeframes, tenants will be able to take direct legal action against you. They can apply to the courts for compensation. They can report you to the local authority, who can then issue substantial fines. And here is something that should really concern you. Repeated failures will be recorded on the property portal and will be visible to prospective tenants and enforcement officers in the future. Your reputation as a landlord will follow you everywhere you go in this industry. There will be no hiding from poor practice anymore. I want to stop here for a moment and address something directly, because I know what some of you watching this are thinking. I know some of you are feeling frustrated, thinking that these rules are unfair, that the government is making it virtually impossible to be a landlord in this country, that you are being treated like criminals when all you are trying to do is provide housing that people desperately need. I hear you, and I genuinely understand that frustration because I speak to landlords every single day who feel exactly the same way. But here is the reality of the situation that we all need to accept. These rules are coming whether we like them or not. They are going to be implemented and enforced. The choice you have is not whether to comply, but how quickly you adapt and get ahead of these changes. The landlords who prepare now, who get their properties up to standard before enforcement begins, who take the time to understand the new systems and requirements, they are the ones who will survive and potentially thrive in this new environment. The landlords who bury their heads in the sand, who hope this will all somehow go away or not apply to them, they are the ones who will be forced out of the sector over the coming years. I am not here to sugarcoat the situation or tell you what you want to hear. I am here to help you succeed in this new environment, and that is exactly why I need you to subscribe to this channel if you have not already done so. The content I produce could genuinely be the difference between you keeping your properties and building wealth or losing everything you have worked for. Hit subscribe right now. Let me move on to the fourth mandatory clause, and this one is going to affect every single landlord, regardless of how many properties you own or where they are located. The new rules on rent increases are now set in stone, and there is no getting around them. Under the Renters' Rights Act, landlords will only be able to increase rent once per year, maximum, and you can only do so through a formal Section 13 notice following the prescribed process. The old method of using rent review clauses built into tenancy agreements is being abolished completely. You cannot contract out of this requirement, no matter how you word your tenancy agreement. Any clause that allows for more frequent rent, increases or uses a different mechanism will be completely void and legally unenforceable. But here is where it gets really important for your bottom line. Tenants are being given much stronger powers to challenge rent increases. If a tenant believes the proposed rent is above the genuine market rate for that type of property in that area, they can refer the matter to the first-tier tribunal. The tribunal will assess what the actual market rent is for that specific property in that specific location, taking into account its size, condition, and features, and they will set the rent accordingly. In some cases, landlords have already seen their proposed increases rejected entirely or significantly reduced by the tribunal. And under the new rules, there is a critical change you need to understand. The tribunal cannot set a rent higher than what the landlord originally proposed. So if you ask for too much and the tribunal disagrees with your assessment, you are stuck with whatever figure they decide is fair. There is no upside to being aggressive with rent increases anymore, only downside risk. This change is going to fundamentally alter how landlords approach rent increases going forward. You are going to need proper, documented evidence of comparable rents in your specific area. You are going to need to keep records of the condition and features of your property that justify your asking rent. You are going to need to be reasonable and realistic in your expectations, rather than simply hoping tenants will accept whatever you propose. Gone are the days of putting rents up by whatever amount you feel like and expecting tenants to simply accept it or leave. The tribunal system is being significantly expanded and resourced to handle the expected flood of challenges from tenants, and tenants are being actively encouraged to use this process to contest increases they believe are unfair. The fifth mandatory clause relates to the new grounds for possession that will replace Section 21. Yes, Section 21 is being completely abolished, but that does not mean you can never evict a tenant again. It means you will need a valid, demonstrable reason that fits within the reformed Section 8 grounds. The Renters' Rights Act reforms these grounds for possession and makes compliance with specific requirements mandatory. The most significant change is to the ground for landlord or family member occupation. If you want to sell your property or move into it yourself or have a family member move in, you can still evict the tenant to do so. However, you cannot use this ground within the first 12 months of any tenancy. And here is the enforcement mechanism that has real teeth. If you claim you are moving in or selling the property, but then re-let it to new tenants within 12 months, you will face severe penalties, including compensation to the former tenant of up to 16 months' worth of rent. That is a massive financial penalty that will make landlords think very carefully before using these grounds dishonestly. There are also significant new restrictions on using rent arrears as a ground for possession. Currently, landlords can begin possession proceedings when a tenant falls 2 months into arrears. Under the new rules, there will be stricter requirements around the notice you must give and longer waiting periods in some circumstances before you can proceed to court. The government's stated aim is to reduce what they describe as revenge evictions, and they are making landlords jump through considerably more procedural hoops to prove that any eviction is genuinely necessary and not simply punitive action against a tenant who has complained or exercised their rights. For landlords who genuinely need to regain possession of their properties for legitimate reasons, these changes add significant time, cost, and uncertainty to the entire process. The court system dealing with possession cases is already massively backlogged. Cases are routinely taking 6 to 12 months to be heard in many areas of the country. Add the new procedural requirements and enhanced tenant protections on top of that existing backlog, and you could realistically be looking at 18 months or even longer from serving your initial notice to actually getting your property back and being able to re-let it or sell it. That is 18 months of potential rent arrears accumulating, 18 months of possible property damage occurring, 18 months of stress, worry, and ongoing legal fees. This is the new reality that every landlord needs to plan and budget for. I have now covered 5 of the major mandatory clauses, but there is still so much more in this legislation that I want to make absolutely sure you understand. Before I continue with the remaining requirements, I want to take a moment to say thank you to everyone who has already subscribed during this video. I can see the numbers increasing in real time, and it genuinely motivates me to keep producing this detailed content that takes considerable time to research and prepare. For those of you who have not subscribed yet, please do it right now before you forget. We are working hard to build the best UK property information channel on YouTube, and we simply cannot do it without your support. Every single subscription helps the algorithm show this content to more landlords and property investors who desperately need to see it. Hit subscribe, tap that bell icon, and let us finish this video together. The 6th mandatory requirement relates to pets in rental properties. Under the Renters' Rights Act, tenants will have a default right to request keeping a pet in the property, and landlords cannot unreasonably refuse such requests. The word unreasonably is doing a lot of heavy lifting in this legislation, and it is inevitably going to be a source of significant disputes between landlords and tenants over the coming years. What counts as a reasonable refusal? The guidance suggests that landlords can refuse if the property is genuinely unsuitable for the type of pet requested, for example a large dog in a small studio flat, or if the lease or freehold of the building specifically prohibits pets. But simply not wanting pets in your property as a general policy preference is not going to be good enough anymore. Tenants can challenge what they consider unreasonable refusals through formal processes, and landlords who persist in refusing, without adequate justification, may find themselves on the wrong end of complaints to the Ombudsman. If this video has been useful to you today, if you have learned something you did not know before watching, please subscribe to this channel right now. Click that subscribe button, tap the notification bell so you never miss an update, and become an active part of this growing community of informed UK property investors and landlords. Then take 30 seconds to share this video with one other person who needs to see it. A friend who owns rental property, a family member who is considering becoming a landlord, a colleague who is a tenant wanting to understand their new rights.